Our most recent webinar. I'm pleased to welcome Michael Mandelstam, who's kindly agreed to speak to us today about the legal changes that have been happening recently. And Michael's got a few slides to share, but he's more open to questions, and hopefully we can have we can have a more organic discussion and explore some of the issues that people might be encountering. Just to make you aware, this webinar is being recorded. It will be shared with the other members of the section, so it'll be hosted on our YouTube channel and accessible via a secure link, and that will be shared to you through our next newsletter, which will be end of November, not the end of this month. So over to Michael. Oh, sorry, if you need to ask questions, please use the Q&A function. The chat is available for you to talk and chat amongst each others, but I won't be monitoring that for questions. So if you post a question in the chat, it probably will be missed. But welcome, everybody.
Okay, thanks. Thanks, David. Actually, just to add to that, yeah, David, if you're happy to look at the Q&A, if people put anything in the chat more generally, I'm used to looking at chat now, so I'm happy to try to pick up what I can anyway. Actually, where is the chat function? I can see the Q&A function, but there's a separate chat function, is there?
Yes, there should be Q&A polls, and chat should be next to it.
Oh, yes, chat's next to it. Yeah, so if anybody wants to stick stuff in the chat rather than the Q&A, feel absolutely free. Because obviously the more people attend, the more difficult some of you may think it is to speak out loud. But equally, I'm more than happy for everybody to speak out loud as well. Because as David said, we're about to look at some sort of housing / social care update relating to your areas of work. And the more interactive we make it, I think the better. Not least because, given that we've only got 2 hours, we want to focus on what's going to be most useful. So, having said all that, as David said, I mean, I wasn't quite sure how to start this session, to tell you the truth. I mean, David has sent through some questions already, which some of you have contributed. So I've got a list of questions in front of me, which I will get to, well, fairly shortly. But I just wondered whether if I put a slide or two up, just to get us going, so to speak, and just to set the scene, just bear with me a moment. I've got all this lined up to go, but as ever, I'm just going to need to get it all in place. Right, let's try it. Yeah. So what I was going to suggest we do is maybe start with this slide. Maybe this is where we'll finish as well. I mean, one can do an awful lot with this slide, I tend to find. And it's just a reminder, I suppose, that whatever questions or issues we want to deal with today, from a legal point of view, you have to slot them into the right place, because otherwise we're not going to know what the answer ought to be. And apart from anything else, a sort of reminder of an overview like this is that if you get questions, like one of the questions David sent to me, which we will come to, what about social services funding for major adaptations? Well, social services funding for major adaptations for adults would take you to the Care Act. For children, it would take you to what's probably best viewed as a combination of the Children Act and the Chronically Sick Act. But how do you get there? Well, roughly the reasoning is, of course, with a major adaptation, you'd start with the Housing Grants Act, which is one act, and it's a completely different act from the Care Act, if that's not too obvious a thing to say. Depending on how far needs are met under the Housing Grants Act, you, of course, and you'll, I'm sure, please forgive me if I'm telling you everything you already know, you would obviously look to see locally what's going on under the Regulatory Reform Order, because that's where, that's the thing that gives housing really a lot of flexibility and powers to assist with housing, including adaptations, if you like, separate from or on top of whatever's happening under DFG, under the Housing Grants Act. So you'd want to see what's available there. And I suppose only then, if you can see that there's needs that are not being met, do you then start to ask questions about the Care Act? Because apart from looking at legislation, of course, you look at guidance, and the DFG guidance last year makes abundantly clear, doesn't it, that if for whatever reason, through the Housing Grants Act, through the housing route, needs aren't being met, serious consideration has to be given to helping with the adaptation under the Care Act for adults or Children Act, Chronically Sick Act for children. But it doesn't quite automatically follow, because you may think that something is necessary and appropriate under the Housing Grants Act. Maybe under the regulatory reform order, a bit of extra help comes along as well. But it is at least, I think, reasonable to say it doesn't automatically translate into a duty to then, say, add another 20 or 30,000 pounds in under the Care Act or the Chronically Sick Act. Because the question that would need to be asked under the Care Act, if it were done one step at a time, is, well, whatever decisions have been made under the Housing Grants Act about what the need may be, are there eligible social care needs under the Care Act is the first question. Then the second question is, well, what might the options be for meeting those eligible care and support needs? And third, of those options, would assistance with the adaptation be a cost-effective way of helping? But if you get that far, if you get through all those steps, then you ought to be able to argue that there is a duty to help under the Care Act. And if you look at the relative costings of options for meeting the need, the adaptation looks pretty good. There you've got a strong argument. And that is actually one of David's questions, you know, what about social services helping? Well, there you go. That's how you get there. And the reason I just started off at the very beginning with that example is to illustrate how important it is to actually know what is going on, so to speak, under which bit of legislation. And that means, of course, knowing, well, what each bit of legislation says, and then also what that means and how it differs from what another piece of legislation may be saying. So there's an example where immediately we've brought in points 1, 2, 5 and 5.1, saying suddenly you've got 4 different bits of legislation involved, depending on whether it's children or adults. But even if we were to just stick with adaptations, major adaptations as a theme, there's another act to put in, of course, there as well. Because what's not always fully appreciated is at point 4, that if somebody has NHS continuing healthcare needs in their own home and they need major adaptations, the continuing healthcare guidance, this is adults now, the continuing healthcare guidance explains that, well, let me just go back a step. As I'm sure you all know, if somebody has NHS continuing healthcare needs, it means, I'm still talking about adults here, it means their health and social care needs must be met under the NHS Act. So that knocks the Care Act out of the picture altogether. But the National Framework Guidance on Continuing Healthcare makes clear that it doesn't knock out the Housing Grants Act. So that if somebody with continuing healthcare was at home and they needed major adaptations, you'd look at the Housing Grants Act as normal. But what's interesting in the National Framework Guidance is that it then says, if for whatever reason somebody's needs are not met under the Housing Grants Act, either at all or fully, by the way, what might the reasons for that be? Well, it might be that what they need doesn't come under the Housing Grants Act anyway, because not every adaptation can come under it. It may be that they get the full 30,000, but actually the works cost 40. It may be that the person suffers under the means test, but on any reasonable view, they could not realistically afford their assessed contribution. Whichever it is, whichever of those it is, the guidance clearly says the Integrated Care Board should consider whether assisting with the adaptation is a cost-effective way of meeting the person's continuing healthcare needs. In case any of you, sorry, and forgive me again, Integrated Care Boards, they're the bodies that replace clinical commissioning groups on the 1st of July 2022, in case you were wondering. And they're now the, what do we call them, bodies, I suppose, responsible for continuing healthcare. The reason I mention that as an example of why, you can't spend all your days, can you, looking at legislation and guidance, but why it may be useful to know what some of this says, because I don't know what your experience may have been, but I know from many reports that if you approach an integrated care board about assisting with adaptations, a fair few of them are likely to think you come from Mars and wonder what on earth you're talking about, and will then follow that up by saying adaptations are nothing to do with us, even though statutory guidance issued by their masters, as it were, the Department of Health, because integrated care boards are answerable to the NHS England and the Department of Health, of course. They're obviously not reading their own guidance. And so, in the nicest possible way, if you know what the guidance says, you've now got another way of trying to challenge them a bit on what's happening and their understanding of what their responsibilities may be.
There's some activity in the chat, Michael.
Thank you. Having said I'd look at it, I haven't. No,
that's all right. So we've got a couple of one of our attendees asks, have there been any examples of where CHC have funded adaptations that you're aware of? We also have another person asks, what's the equivalent regulations for Wales and the structures there? And then we've got another asking about what's the situation with children.
Yeah, all nice, difficult questions. So, well, first of all, I've got no idea to what extent or where continuing healthcare are funded adaptations, but I know they do. But I can't remember where. I mean, people tell me, quietly, the NHS has been involved in different places for years, with doing adaptations. NHS has sometimes done showers and stuff like that and other adaptations. It's just they probably don't trumpet it because they don't really want people beating their way to the NHS door. So I'm afraid I can't give you concrete examples. Tell you the truth, if you want examples, I'd have thought a far better source would be your OT networks. I'm sure many of you, all of you belong to OT networks. Sometimes I accidentally get involved in an OT network and I see I'm on some email list or social media thing of hundreds. I'd have thought maybe that might be a possibility to just ask around where people have examples. So that's a thought on that. I've always tried to reference role of CHC to no avail. I mean, the trouble is, it's all very well, isn't it, for me or anybody else to say, it can be useful to know what the guidance says, or indeed what the legislation itself says. It can. I mean, there's nothing to lose, but equally, it's not a magic wand. And I do a lot of continuing healthcare training for different local authorities and sometimes the NHS as well. And, I'm not surprised actually anymore, but repeatedly, there are things going on locally in continuing healthcare which are directly contradicted by both the regulations and the guidance. One of them is the adaptations thing, that despite what the guidance has said for a good number of years now, still integrated care boards just shut their ears to any discussion. I think all I'm saying is that if you identify the paragraph or two in the guidance By the way, you can easily do this. You just look up the national framework on continuing healthcare. You should do a word search, say adaptations. You'll find the things straight away. What I'm saying is there's nothing to lose. And if you sound like you know what you're talking about and you can point to regulations or to guidance, it can only help your argument. But yes, there's no guarantee of success. In terms of Wales, now you see that's an interesting thing. In principle, continuing healthcare in Wales would legally be the same as in England. But in Wales, there aren't the detailed regulations that there are in England. And the national framework guidance is different to the extent that unless it's changed recently, I don't think it has, because it changed fairly I think it changed last year, didn't it, in Wales, the main guidance on continuing healthcare. It doesn't actually mention the adaptations bit in the Welsh guidance, which it does in the English, and that's not, of course, immediately helpful. However, I actually do think it would be legitimate in Wales to say that, and stop me, it's Sue, isn't it, if this doesn't sound right to you, but if you were to say in Wales, look, the basic legal position in England and Wales is the same. And by the way, the reason it's the same is that continuing healthcare in the end is based on distinctions between the NHS Act and in England, the Care Act, and in Wales, the Social Services and Wellbeing Act. And therefore, some of you may have heard of an absolutely fundamental and seminal legal case called the Coughlin case, Coughlan, Pamela Coughlin, a 1999 Court of Appeal case, which is fundamental to continuing healthcare. And it's based on the NHS Act in England, essentially, and on the distinction with social care. Well, in Wales, you've got the NHS Wales Act 2006, which in some respects is of course now different than England, but in the fundamental respects of what is healthcare and what social care is pretty much the same. What I'm trying to get around to saying, Sue, actually, in a slightly long-winded way, is if you were to say, well, look, the English guidance is saying a result of the underlying law is that if somebody needs more than what they can get through a DFG, through the Housing Grants Act, and they have continuing healthcare in their own home in Wales, then it should be open to you to use the same argument that could be used in England. It's just because the Welsh guidance doesn't mention it explicitly, it's just not so helpful. But I don't think that means the argument couldn't be made in principle. But as we've already said, even in England, even if you take horse to water and point out this paragraph to health, they still might not take any notice of you, I'm afraid to say. But at least you've done your best. Yes, so, yeah, and Joe, yeah, I knew somebody. As soon as I said adults, I knew somebody was going to ask about children. And the trouble is that going back to England, I suppose you might read the same into Wales as well. The slight complication with children is that, first of all, I don't know whether you've looked at it, Joe, or anybody else, but there is some separate guidance on children's continuing care. It's called National Framework for Continuing Care for Children, which I think was 2016 that it was last published. And actually, one of the very first things the guidance says is, well, continuing care for children isn't quite the same. Now, I suppose the short difference, at least as far as the government is saying the position is that whereas with adults, we said a few moments ago that under the NHS Act, once somebody's got continuing healthcare as an adult, health must meet all their health and social care needs. Under the children's guidance, what it's saying is there will be far more mixed up packages of care or provision of services, or whatever we call them, split between healthcare under the NHS Act, social care under the Children Act and the Chronically Sick Act, and education, of course, in England under the Children and Families Act. Now, I don't know. I mean, if you were interested in this, but you may already be familiar with it, the children's framework, if you look through it, it contains something called a decision support tool, which is looking at the child's needs through a series of domains of need. And that the purpose of the decision support tool is to identify at least that part of the child's needs that would be regarded as continuing care on the healthcare side of things, and therefore would identify what it was that health should be funding in respect of children. Now, I think in practice, you do sometimes get health funding pretty much the whole package. But equally, you may have many cases where they're not. And somehow you would need to try to work out if you could make the argument for certain types of equipment and adaptations. Now, that sounds slightly vague. It is a bit, I'm afraid, because, and then I'll stop on this point, that the NHS regulations in England that deal with all of this, they actually define continuing care for children differently than they define continuing healthcare for adults. And that definition, and this is in law now in the regulations, do say that continuing care for children is that part of a child's care package that is to be funded by health. And that clearly leaves open the joint packages, whereas the very same regulations for adults say that once an adult has continuing health care, then all their needs, at least health and social care needs, must be arranged and funded solely by the NHS. And there is a troublesome distinction. So I hope that makes a little bit of sense. Kirsty, you're stretching me now because about Scotland. Scotland's gone out on a limb with continuing healthcare. You probably know more about it than I do, but a few years ago, Scotland changed, didn't they? And I believe this is still the policy. Isn't Scotland saying these days that there is no continuing healthcare unless it's in hospital? Sorry, that's a rather brief answer.
Yeah,
Position,
Michael. I think
now,
it is.
And now nobody's actually, as far as I know, Kirsty, challenged that in Scotland, and it may not be the sort of thing you would get into, I don't know, but there's been a very recent case in Northern Ireland. Now, Northern Ireland, a few years ago, they changed their policy to a position that looked suspiciously like Scotland. And recently, there was a challenge to that. And the judge didn't like what Northern Ireland had done, saying that it didn't make sense. The judge didn't think, in this continuing healthcare context, to think that continuing healthcare could apply in hospitals only. I'm going to have to leave it there, Kirsty, I think.
Yeah, it's a shame. It's a shame. It's complex because it comes into this kind of self-directed support arena then, in terms of care provision at home and making sure it's adequate, etc. So
yeah,
Scotland is taking that route more so than the NHS funded side.
But presumably, Kirsty, if that is a position in Scotland, that continuing healthcare is really largely confined now to hospital settings. Just going back to what we're trying to answer here, with adaptations, have you still not got the argument? I mean, you've got the Housing Act, haven't you, in Scotland, that covers adaptations, and it covers different types of adaptation. But in Scotland, you could surely, well, actually, just out of interest, do you then sometimes make the fallback argument saying, well, under the Scottish Housing Act, this person's needs aren't being met for whatever reason through the adaptation system? What about falling back to the Social Work Scotland Act and the chronically sick? The chronically sick act in Scotland is still going, isn't it, for children and adults? as I recall. Could you make a fallback argument in Scotland there to say that social care needs to step up in some cases for adaptations?
We could, and we have actually. I know of a couple of instances where we've added to a grant, because the Scheme of Assistance grant in Scotland under the Housing Scotland Act only provides for adaptations, doesn't provide for living space. So we have had situations where we've had no choice but to deliver on living space based on exceptional circumstances. They're not often, but they are there. So that's where the biggest difference between the DFG and the Scheme of Assistance lies. And it is incredibly frustrating when you hear such good work being done in England to support higher level adaptations where rehousing really isn't an option. But yeah, I mean, as everybody else's budgets are, the social work budget is incredibly stretched, and they have the right and the potentially the say so to refuse any additional funding unless it's mandatory, like you say, Michael. And yeah, it's frustrating, really frustrating.
I mean, Kirsty, so I don't know how many people from Scotland on this call, but can I just tidy one quick thing up? Look, it's so long. You know, I used to come up to Scotland a lot. I haven't been up to Scotland for ages. I've sort of got a bit localised as I've got older. I haven't been making the trek, so I may have lost touch a bit. But with the housing grants, the adaptations grants in Scotland, you're still talking. Is it still the standard amenities stuff plus then other adaptations for sort of welfare, accommodation and stuff like that? Am I right in thinking that?
You're absolutely correct. It's still the same legislation as it was in 2006, I think, and it hasn't been updated as far as I'm aware. There is a kind of pressure on the Scottish Government through Housing for Scotland 2040, I think, is a new legislative housing document that really states in one of its parts, it's only a one page, unfortunately, of about 77 pages, but it does state that there needs to be a review of the system to streamline it and consider that, because we also have the situation where we have two other budget funding streams for housing that is council properties and housing revenue accounts that sit alongside that. They use their own revenue accounts for adaptations and have their own policies around that. And we also have stage 3 applications for housing associations that's central government funded, that they get and bid for annually to be able to provide adaptations within their own housing associations. So it's a very complex budget.
Yes.
Budget map, if you like.
Yeah, I mean, there's a couple of things about it, and we can bring it back because obviously I imagine most people on the call are England and Wales, probably England. But anyway, we can bring it back to that from something you said. But two quick things. I think you were saying additional space isn't covered, and that's the way the Housing Act's been interpreted, is it? That you can adapt existing space but not create additional space. Is that what you were saying?
It does say that, except for access to bathing facilities or shower facilities where an extension can be considered. But extensions would not be considered for living space. That's the way.
But that's in the guidance, isn't it? That's not in the legislation. And that may be, Gina, I'd have to look at it again. But one always wonders sometimes with things like that whether it might be challengeable. Well, that's one thing. But the second thing, and this brings us sort of back to England and Wales as well, is that my recollection is in Scotland, I think you were saying that council tenants, you know, the council's going to do it out of his own housing revenue account and so on. They're not going to go down through the adaptations rules in that Housing Scotland Act. But I seem to remember, because years ago I did some work, and you know, I'm ever so ashamed to say I've forgotten the OT's surname. I knew it was Susan. You know, she was the OT up at the Scottish office, and then I can't remember her surname. Sorry,
Susan Kelso.
No. It's
No.
another thing.
Right.
Okay, the point is, I did a bit of work for her for the Scottish government at that time, and we looked at the adaptations thing. And my recollection was that, in principle, of course, all the Scottish councils would always deny it, but that in principle, the adaptations rules that we've just been discussing should have applied to council tenants. It's just that the practice had grown up that they never would be used. And I don't know, I'm sure that was the legal position, Kirsty, in theory, but that nobody ever took any notice of it. But the interesting thing is that there's a parallel, you see, in England, because, and now this brings us back to what's in front of us, because under the Housing Grants Act, it has been known for years that people's right to apply for a DFG has got nothing to do with their housing tenure. And the guidance has always said, that, look, if, as you said in Scotland, Kirsty, if an English council or Welsh use their own resources, their own housing revenue account or whatever it is, to do their own adaptations rather than go through the grants rules, that's absolutely fine, as long as the person gets what they would have got had they used in England the DFG system. And therefore, if they didn't, either because they couldn't get the right sort of adaptation, or because it would take much longer than a DFG would, people would need to be informed that they were entitled to apply for a DFG. Now, my understanding is that the position is, or was anyway, the same in Scotland. But an example how, despite after all these years, this lesson has still not been really taken to heart everywhere. I don't know whether some of you are aware of quite, I think, a significant, well, there's two, significant Ombudsman case. Not long ago, it was a few months ago, earlier this year, I think it was published, involving Runnymead. I don't know whether any of you are on the call from Surrey, but Runnymead is a housing authority down in Surrey. And a reason it's worth probably mentioning this case is because the social services OTs, as far as you can see when you read the Ombudsman's report, the social services OTs covered themselves in glory, really, because what you had was a family in council housing who needed certain adaptations that the social services OTs were saying were absolutely necessary and appropriate. And to cut a long story short, the housing authority, Runnymead, within the Surrey County Council area, twisted and turned and came up with every non-defensible excuse for not doing them. But the social services OTs, I mean, effectively on behalf of the family, persisted in putting pressure on the housing council, and then drew the council into the sort of statement that means if it's an ombudsman case, you'll lose the ombudsman case, and if it's a legal case, you'll lose a legal case. The housing authority ended up by saying that they were very sorry that the family had been misinformed about the meaning of the legislation, because they then said disabled facilities grants do not apply to council tenants in any circumstances, and the family had been misinformed. Well, of course, the only misinformed people in that case were Runnymead Borough Council, who obviously completely misunderstood the legislation, which has only been there, hasn't it, for getting on for 30 years, and all the guidance that's been issued on home adaptations, 4 years, not just the latest stuff last year, but the guidance before that and the guidance before that have all made clear that council tenants are eligible for DFG. Sorry, that's all a long way around, Kirsty, moving back from Scotland to England, but I hope that was useful.
It was, thanks, Michael. I think there was a wee question in the chat to say, would there be somebody in Scotland that we could talk to about that? So I think that's probably a good thing to start the conversation and see if there's any way that we can get sort of clarity on the legal side. But yeah, everything that you've said, it kind of makes sense.
I mean, do you know, Lisa, I mean, just out of interest, I've got I've got a bit of time. I've got a bit of time in the next week. I might, just for old time's sake, have another look at the Scottish Guidance. I've got a feeling there's one or two things in there. I might, perhaps I could email it to David or something, and he could pass it on to you if I
That would be
turn
brilliant.
up any
Thank you.
thoughts,
Thank you, Michael.
things that you've raised. Right. So, yeah, the next one, Lisa. Yeah, bespoke ceiling trap.
Sarah's
Yeah,
asked,
so Lisa, yeah, well, where did this extra funding come from then? Where the ceiling track hoist, you exceeded mandatory DFG and top up funds, but did you get the money in the end?
Yeah, CHC funding for those ceiling track hoists.
Oh, I see, you did get CHC funding. Well, that's
I
good,
did get
isn't it?
CHC funding, yeah.
Yeah. Gosh. Am I allowed to ask which area you work in?
Yeah, no,
Just
yeah. Hampshire County Council.
Oh, goodness me. That's good, because it's not. Was it easy to do? Did they immediately see the logic, just out of interest?
I didn't have any problems at all, actually. I just put in my reasoning for why, and I obtained the quotes, and I was really supported.
Wow, that's great. And you didn't have to point to the guidance or anything like that?
No, nothing like that. Just get the do the legwork, get the quotes, and then put in the reasoning why it was necessary. So no, really supported.
Yeah, that's great. That's cheered me up considerably, really. Thank you for that. And thanks, Louise. You're pointing out to what page in the National Framework Guidance in England there is this discussion about adaptations. And thank you, David, possibly, is that you put in where the Welsh continuing healthcare and you're putting all the links in, and the children as well. Thank you. All right.
We've got Sarah's asked in the Q&A, is there a link to the Ombudsman case that you were talking about?
Oh, yeah, well, there would be a link if I had it up. I mean, I could stick it in a moment if you want. You'd easily, if you go onto the Ombudsman's website and you stuck in Runnymead, you'd find it very quickly. But
somebody's already popped it in for us.
You're all ahead of me. Thank you.
Already there.
Yeah, great. Right. Oh yeah, the Anne, Northern Ireland. Yeah, the case. It's called McMinnis. McMinnis. It's the McMinnis case.
I've put a link to it on the Northern Ireland People's Commissioner website.
Yes, thank you for that.
Yeah, because the Commissioner for Older People was involved, because in Northern Ireland, so there were two aspects. There was Robin McMinnis himself, but then the Older Persons Commissioner in Northern Ireland had been disturbed about what was going on with continuing healthcare in Northern Ireland. Sorry, I've got my boxes all messed up here. Give me a moment. It's better. Okay. Should I carry on? I mean, is this helpful to go running through these questions, David?
Oh, definitely. Definitely.
Yeah. Okay. As Michelle is saying, yes, just like council tenants, registered social landlord tenants, of course, have a right to DFG as well, but you're always faced, of course, with landlord permission, which is the point you're making. It's interesting, actually, in that respect. A case that I'm sure many of you, maybe all of you, are familiar with by now, or certainly those of you working in England, the Islington case of 3.5 years ago. Mrs. McEwen was the woman involved. She was a council tenant in Islington, And I suppose, you know, thinking of this thing of landlord permission, one pattern that sometimes emerges with council tenants is that the local authority is in a strange position, because on the one hand, they're responsible for making the DFG decisions. And in the Islington case, by the way, Islington weren't saying that council tenants couldn't apply for DFG. But the local authority is also in the position of landlord. And the risk is that even if the local authority accepts people making DFG applications, so they're giving with one hand, but then they immediately take away with another by refusing landlord permission, so to speak. Now, the judge in that Islington case, there's ever such a lot of points, by the way, in that Islington case, that McEwen case, but one of them is that the judge was absolutely adamant that the local authority, in looking at DFG, should not be treating council tenants differently than people in other tenures. And also that the local authority needed to be absolutely aware of keeping these different functions separate. And effectively, you could argue that what the judge was saying was that the local authority should not allow its interests as landlord to effectively completely undermine council tenants' rights to DFG. So that's what, yeah, that sort of does run you potentially into landlord permission issues. Sarah, yeah, we've got the link to the Ombudsman case, I think. And by the way, Sarah, on this council tenant issue, the DFG guidance last year, if you look that up as well, about council tenants, it's clear that they're eligible for DFG. By the way, as you probably know, the confusion has been that the money that comes down from central government for DFG is not available for council tenants. And what some councils are taking that to mean is that means that council tenants aren't eligible for DFG, but they've got things mixed up. They've got the money mixed up with the law. All it means is that council tenants are eligible, but the council needs to find the money other than through that government funding. That's all. That sounds a bit confusing, but that is actually the position. Yeah. The debates about private therapists, that's from Charlotte. I'll just digest that for a moment. Charlotte, you know, I'm sorry here. I think I might be lost. You know, your first point about the role of private therapists and the CHC team. Would you mind? Sorry, I'm sure I'm being slow. Could you rephrase or simplify? Would you be happy to talk out loud about that?
So I think it's just there's some cases that we're working on where we've been instructed by a deputy and maybe they've already got CHC funding or they become eligible for CHC funding. And we've made our assessments of what is appropriate for somebody's needs, but that wouldn't necessarily be in line with statutory. That would be just our independent clinical assessment. And obviously, when CHC are involved, we're getting a really mixed message. So we're getting sometimes where the CHC team is saying there shouldn't be any private therapists involved whatsoever. We should be meeting all the needs completely. There should be no need whatsoever for a private therapist. And I'm like, great, that will save my client money. That's not a problem whatsoever. Are you going to do the vehicle? Are you going to manage the plans for this, the plans for the therapy room, or whatever it might be? And then there's this pullback thing, oh no, because we wouldn't consider those as needs. And it's whether there's anything tangible. It seems to be being worked out very much on independent clinical opinion, and it seems very mismatched across different areas, different counties, different ICBs as to what the view is around it. And we've got one package where they're saying, oh, we acknowledge there's some physio need there, so we'll fund that, but actually, yeah, we wouldn't fund about sorting out a vehicle, so we're not going to fund the OT for that or provide the OT for it. It's just very mixed match. So I've got deputies saying we really want to instruct you and we're going to keep instructing you, and others saying the ICB are telling us we shouldn't be instructing anybody because they'll meet their needs. It's something that's just come up probably in the last 5 months or so.
So this is
Might not make any more sense after that waffle, but
yeah, no. So what you're saying is, so you've got people who are lacking mental capacity, and there's been a welfare deputy appointed. Yes.
Yep.
Right. And so the welfare deputy is using you as a private OT to assess certain types of need.
Yep.
And make recommendations back to CHC about what
back to them initially.
you think they ought to do.
So we would then usually give a steer as to, this is what's clearly been eligible and we should be pushing for from statutory services and trying to work in collaboration. But then there just seems to be a very mixed approach as to, where you agree the thresholds of funding and different views on whether we should even be involved at all.
Yeah, well, this is quite interesting, actually, and I'll try to, because we may be able to, well, I'm hoping we might answer your questions, but also broaden it out as well for others, sort of some wider issues. I mean, the first thing is, when you said, oh, they're telling you, or telling a deputy not to use a private OT, well, actually, that's the deputy's decision. I mean, if a welfare deputy thinks it would be useful and would be most importantly, of course, in the person's best interests, that a private OT were used to look at certain types of need, that's the deputy's decision. I mean, there's nothing to do with statutory services. That's up to the deputy. But of course, in terms of then acting on the deputies or rather your recommendations through the deputy put to health for somebody with CHC, if somebody has continuing healthcare needs, the duty ultimately on the integrated care board, as we said, is to meet that person's needs, their health and social care needs. It is ultimately they make the decision as to what a need is, okay, maybe as opposed to a wish, for example, because they only have a duty to meet needs. And as they're the decision makers under the National Health Service Act, in the end, it is for them to take a view on what's a real need and what isn't. But of course, if your private OT recommendations are put forward to them, then you'd say for them to make a legally sound decision, they would need to do at least two things. First of all, they would need to take account of what you're recommending. And if they were going to make the decision properly, if they're not going to follow what you recommended, they should provide a justification and a rationale for not doing what you're recommending. The second thing is that if they say no because of a misunderstanding about the law, then that's another problem. Because, I mean, supposing they said no to a certain type of provision because they said, well, we don't do those. Okay. Well, if anybody, whether it's the NHS or a local authority, says, oh, well, no, well, we don't do those. Well, obviously one needs to check why they're saying that. Is it just some local encrusted policy? Or are they saying, no, as a matter of law, what you're asking does not come under health or social care needs, you see? So the vehicle, you see, well, that's an interesting question. When you say vehicle, what do you mean? Do you mean
an adapted vehicle? So there's obviously some funding made available separately through Motability schemes, but often there's a cost in addition to that to meeting someone's appropriate needs.
Yeah, so, I mean, if they argue, I mean, to say it's a vehicle, health or social care, well, there's an interesting health. It could be either health or social care, well, maybe. And in the end, you need to say, well, why do you think there isn't a need for you to do this. And they might say because use of the vehicle brings in other things which don't really come within the essential health and social care needs. Maybe they'd say that. But there is something that, as I began slightly to understand what you're saying there, which does introduce another issue, which I hope might be of wider interest as well, because some of you may be aware of a Redbridge case, a Redbridge High Court case involving a DFG. And you'll remember it if you know it, because it involved this man, and it was very, very disabled, who had a through floor lift. And the question was whether the backup, when the through floor lift malfunctioned, should be either an emergency call out service or a stair lift, which would be used not routinely, but merely as backup. Now, the reason why this could sort of relate a bit to what you've asked is this. The man was continuing healthcare, and the OT who said that this stair lift as a backup was necessary and appropriate was an NHS OT. But this was a DFG case, and the Housing Grants Act says that in deciding about a DFG, housing must consult social services. And the thing is, social services, and housing, they didn't agree with this recommendation, you see. And the interesting question about this is as follows. See, although we said that with continuing healthcare, the NHS has to meet health and social care needs, we said that the Housing Grants Act falls outside of that. And the reason that it seems for that is because it's a housing need. Well, you can tell in the title, can't you? The Housing Grants Act is not social care legislation. So in my view, hasn't been tested, but in my view, and I'm often asked this by OTs, I think the consultation duty still applies to social services, even if the person applying for the DFG has continuing healthcare needs. I'm hoping, maybe there was a link to what you asked, Charlotte, maybe. But this is important because what had happened was housing in that case. I don't know if any of you read the case. You might have a different take on it than I have. But housing accepted what this NHS OT said. Even though it wasn't a social services OT, they accepted it, that this stair lift was necessary and appropriate. But then they didn't really want to provide it. So they then came up with another excuse for not providing it, which was completely unlawful. I hope I haven't gone off the track. I hope anyway that might have hit a few things.
Yeah, thank you.
Okay, I'll move on a bit. Right, the link to the Islington case. Oh yeah, it's all links, isn't it? Yeah, look, it's McEwen v Islington. You'll easily find a link to it. McKeown, McEwen v Islington. It's around about April 2020. It's a dead interesting case, that. Actually, while we mention it, it's probably something I should have mentioned anyway. I imagine some of you will know it, but obviously maybe not all of you. Thanks, Charlotte, for that. Yeah, very helpful. You put the link in. Amongst other things in that case, see, this woman's Housing Grants Act on our overview here, she wanted this external platform lift because she lived in a two-level council maisonette. The entrance to it was below ground, you see. She couldn't negotiate those steps. And I think a couple of her sons lived fairly nearby, and they used to have to carry her up and down the steps. So she wanted the external platform lift. But one of Islington's argument for not approving the DFG was that she wasn't applying for other rooms, parts of it inside the dwelling to be adapted. And they say then the reason that matters is because looking at the long term, the maisonette may then prove to be unsuitable for her. so they wouldn't do anything, and said that in order to qualify for DFG, they would have to be satisfied that the dwelling, including in the long term, would be suitable for her needs. And the judge did not like this at all, because the judge said, first of all, he didn't actually use these words, but effectively said, you don't want to be crystal ball gazing too far in the future. You may need to look a bit in the future, but you're not crystal ball gazing in the long distance, firstly. Secondly, the judge pointed out the word suitable isn't even in the Housing Grants Act. The words are necessary and appropriate, and then are reasonable and practicable. And the judge pointed out that if you looked at what she was applying for, the external platform lift, it was indeed necessary and appropriate to give her access in and out of the dwelling. And as far as reasonable and practicable concerned, Islington went way off, because they said it wasn't reasonable and practicable because it wouldn't be suitable for her needs. Well, the judge pointed out that what the legislation states is that reasonable and practicable is only to do with the age and condition of the dwelling and nothing else. So the judge said, if you're using those words reasonable and practicable, it's absolutely irrelevant what her needs are. So, you know, if you don't know the case, it definitely has got a lot, I think, a lot of points of interest for OTs and actually anybody else involved in DFGs. Let me pause. I think I've got to the end. Have I got to the end of the questions, the chat?
David, in the chat, yes. There's two in the Q. Yeah, there's two in the Q&A, which kind of relates to what we've been talking about. But they're more around DFGs and funding in council properties.
Yeah. What shall I answer those, and then do you think maybe a sort of a 5-minute break or so, fairly short?
Yeah, I think so. Definitely.
What I'm trying to do. Do you know, these days I use Zoom so seldom. I can't see. I've lost my bar. Sorry about this.
Do you want me to read them out, Michael?
Oh no, it's all right. I think I've got it back. No, I got it back. Right. So they don't have to use HRA. Yeah. So Alison. So what we're saying is what the guidance has said over the years, and what the Ombudsman has said. So if you've got a council tenant, the central government DFG money is not available. So one of the things has been, well, the council can have its own scheme of adaptations for its own tenants, HRA funding. And as long as the person's needs get reasonably met, that's great. But what the legal position is that if they're actually not getting that HRA funding, and in your question, that would seem to be the issue, you're saying it's run out or something, then the tenant should be told that they can apply for a DFG. And if they're eligible for it, then in law, the council would need to find the money from somewhere. I mean, that's the theory. But not sort of ring-fenced, as it were, DFG money. That's what, and I mean, there's a paragraph about this in last year's guidance, in fact.
Can I just come in on that? Because sorry, I'm Alison that asked the question.
Oh,
because
yeah.
hi, we've gone round the houses trying to find the right answer, and consulted our legal department, and also Clive Martin at the foundations, who does a lot of the training, and it seems to be they're saying that actually it may be possible for DFG funds to be used for council tenants as long as your Better Care Fund agrees. But we're just really stuck with this now, because it's really, nobody seems to have, you know, a conclusive answer.
Right. Well, that's something Look, Alison, we're going to have a break in a moment. When we have the break, I'll just quickly look up that paragraph in the guidance, okay? Because I'm not 100% sure that reference the Better Care Fund sorts it out, really, because all the Better Care Fund money does is channel into these different bits of legislation. But also, I would say that you're talking, understandably, you're talking about funding because you have to find the money somewhere. But being rather simplistic about it, if the law is that council tenants are eligible for DFG and any one particular council tenant, you know, in principle, ticks all the boxes, the council's got to find the money. If you see what I mean. Yeah. So I understand that if you're within the council, you have to find the money, which is what I think you're saying. But from the point of view of a legal case or an ombudsman case, this is a slight overgeneralization, but the court or the ombudsman is not going to be worried about where you find the money. All they want to know is whether there was a duty, if you see what I mean. But I'll look up that paragraph and we'll see whether.
Would there be a time scale on that? You know, because we're being told, well, maybe in a year there might be more money, but you know, is there a time scale?
But because if we're saying that council tenants are entitled to either DFG, well, they're entitled to DFG directly, or if you're not going through DFG, they're entitled to DFG equivalent. Well, that would mean that the DFG timescale should apply.
Okay.
And as you know, in the Act itself, applications must be decided within 6 months, and payment be available. You know, it says 12 months, doesn't it? But it's 12 months from the date of the application, not 12 months from the date of approval. So that's your timescale in the legislation. And then, of course, in addition to that, you'll be aware that in the guidance issued last year, there were these timescales set out, weren't they, for the sort of more urgent cases, the medium and the slower ones. But even the slower ones is still all within that legislation timescale. So that's the timescale that you would want to be working to, however you're finding the money.
Okay, thank you.
But I will look that paragraph up.
Okay.
And shall I make it a last question? Because Alison, you got in there again.
I've covered that. I've covered that, so don't worry.
Oh, have you?
I didn't realise it was a separate chat box to the question box, but yeah, don't worry.
But we haven't covered section 114.
Oh yeah, well.
I don't know whether everybody knows what section 114 is. Alison, I've come across you, haven't I? Which council are you in?
Woking. So yeah, basically.
Oh yes, Woking. Like Croydon.
Yeah.
Like Birmingham. Birmingham's the biggest. Apparently, is it? So I read. It's the biggest local authority in Europe or something. Don't understand that. Anyway, apparently Birmingham is. Anyway, the thing is, they're under a section 114 notice as well, and this means that the local authority is bankrupt. I assume, are you getting at the fact that under a section 114 notice, the council's obviously got to be very, very wary of continuing expenditure, and it's going to say that it shouldn't be doing things other than statutory functions. Is that the phrase that's come your way, perhaps?
Yeah, yes.
Yeah.
But our argument is this is statutory.
Well, this is absolutely. Look, all these things we're looking at, the duty to approve and then deliver DFGs, the duty to meet needs under the Care Act, the duty to do things similar under the Children and the Chronically Sick Act, the duty to meet people's continuing healthcare needs under the NHS. Well, actually, forget the NHS because we're talking about local authorities. These are all statutory functions. So I don't know whether, I'm sure nobody would suggest if anybody said, oh, well, we'll just chop out the DFGs for a couple of years because they're not really a serious statutory function, well, that would be a mistake.
Yeah, that's what's happened. Yeah. Okay.
Yeah. Well, sorry, that's what is that? So what's being suggested?
Yeah, that's what they've told us. Yeah,
Oh, right. But are you challenging that then?
we're trying, but not getting anywhere.
Well, that's
Because
really
they
interesting.
say, because they've been to legal and they say that we can use DFG budget, and so we should be doing that.
Oh, I
With
see.
state.
So they're still so they're accepting that people. Oh, I see
Need,
what you mean.
yeah.
Yeah. So, but because are they saying that it's all so vague and discretionary using the HRA for council tenants? Maybe that's not really a clear statutory function. The clear statutory function is the DFG. Is that their line of argument?
Much.
But the problem then is that all they're doing is flattening a molehill in one place, only for it to pop up 10 meters away, aren't they? Because if you say, well, the HRA is not a statutory function for adaptations, well, I'm not sure whether that's correct or not, but even if it is, you're now diverting tenants to another statutory function where there's an absolute duty to find the money. So I don't see how that would really help.
Well, I mean, in our we have a good DFG budget, and we have some non-means tested grants. So in theory, you know, it would be a case of stopping our non-means tested discretionary grants to be able to pay for council adaptations.
It could lead, couldn't it? So you mean it could lead to cutting down what goes on the regulatory reform order, for example?
Yeah.
That's possible, I suppose. Look, shall we have a 5-minute break? It's 25 to 3. Should we make it about 5 minutes, and then we'll pick things up again? Okay, thanks.
Yeah, fantastic. See everybody shortly.
Okay. So shall we just pick up again a bit? Just one thing, just to sort of finish off what we were talking about before the break, Alison. I mean, you probably know this, but I don't know whether it gets us anywhere in what you were referring to. So this bit, I've just slid across this bit of the guidance the last year. Government funding for DFG intending to fund adaptations for owner-occupiers, private tenants, housing associations. Eligible council tenants can apply for DFG the same way, but local housing authorities with HRA should self-fund home adaptations through that account. A provision was made for expenditure in the HRA as DFG allowance in the past. Does that make any sense? It may make more sense to you than to me, but that's clearly suggesting that the DFG money isn't to be used for council tenants, but you're saying maybe there is some flexibility locally.
Well, the advice that we were given from, say, I don't know if you know Clive Martin, but and also our legal team was that if the Better Care Fund say it's okay, then we may be able to use.
Right. Yeah. I mean, it's just that. Look, I'm sure they're right. If you taken advice from them, we'll just go with that. I mean, quite honestly, if you can find the money from somewhere, who cares?
Yeah.
As long as you can find it. But the only thing is that statement, because the Better Care Fund contains this DFG money, doesn't it, from central government? And the central government guidance last year is saying it's not intended for council tenants. Now, if your advice, your legal, look, I'm not going to contradict your legal section. I'm not giving you legal advice. If they're giving you legal advice,
I'm not sure they actually know. They're not experts. Anyway.
Oh, I see. Oh, right. It's just well.
No, I appreciate your
Yeah.
time, because I know it's. I don't want to take up any more time, but yeah,
It's an important issue, though, Alison. It's an important issue because I mean, I mentioned the Runnymead case, but there's been another case recently as well where the same thing happened. The local council was under the impression that council tenants weren't eligible for DFG. So it's a very live issue.
Okay.
Not
Alison,
in all
can I ask? There's a couple of routes at which DFG can be funded. There's some money that comes from the Better Care Fund that's allocated for DFGs, but local authorities are also supposed to top that up. The Better Care Fund was never meant to replace what the local authority puts into the same pot. So there might be some restrictions on what they can spend out of the Better Care portion that they put into their DFG budget. But if they're using their own capital budgets, then they might have to use that portion of the money to fund something in their own council property.
Our council contribution was for discretionary grants, which has now been cut. So yeah. Okay, thank you.
Okay. All right.
Yeah.
So look, where we go? Do you think perhaps before ploughing on, I ought to check with you all? I mean, the way we've been doing this and the issues that we've been trying to cover, and I've been trying to answer. I mean, is this sort of generally useful so far? Because obviously the session's for you, it's not for me. So if you think we're not quite on the right track, or I'm missing important things out, or not explaining things, I mean, please do say. Or put more stuff in the chat. Or okay, well, I'll leave it to you to raise things or say put things in the chat. David, do you think it might be sensible before we go any further for me to turn to the questions that you emailed to me?
Oh yes, please, if you could, Michael, that would be really helpful.
Because otherwise there's a risk, presumably, that we might lose them. Do you know what I think I'll do? You just bear with me then a moment, because I'm so not used to this. Just just bear with me. I'm going to have to. I'm going to just stop sharing for a moment. Right.
I think so far, Michael, everybody's happy with the
Okay, so it's not a disaster so far then.
well, I put a poll out, and so far 96%, 97% of everybody's happy.
Thank you. Well, thanks for confirming that. I'm just what I'm going to do actually is put these up on the screen so we can all see them and I can see them properly.
Share my screen.
It's okay. Do it that way. Okay. Right. So I'll put these across on the screen now, so we can just see these questions that David emailed me. So. Right, that's going to bring them up. Yeah. Now I think we've done the first one, haven't we? Because we've just been talking about the section 114, the HRA stuff. Second one, can DFG funding be used to take out a wet? Oh yeah, this is all an issue, isn't it? Yeah, so they can get in and out of the bath. All right, no, you want to take out a wet room, you want to put in a bath. The reason being, for example, that shower is giving somebody a burning sensation, or people are asking for it for pain relief. This has been a question, hasn't it? Particularly that pain relief one that's been around for absolutely ages. Do you know what? I'm going to just flip forward. So here are our DFG rules, and you know you have to do this in order, don't you? We've got the disabled occupant, is it their only or main residence? Do the works that they're applying for fall within the list of purposes in the Act? If they do, are they necessary and appropriate? And then the reasonable and practicable bit, well, we mentioned that earlier. So I think the question you're asking here is, could they fall this getting rid of the wet room, put in a bath because of some, what you might call a medical thing, pain relief, fibromyalgia? Let's have a look. Now, this may relate actually to another issue that often comes up, particularly with children anyway. But I wonder if you were taking a really strict legal approach to the words. F is the bit about facilitating access to or providing the disabled a room in which there is a bath or shower. Well, if a person can, in principle, access the shower at the moment, clearly they're accessing the shower, aren't they? But then there's a comma, isn't there? Or facilitating the use by the disabled occupant of such a facility. So what I'm wondering is whether, if you wanted to make, I mean, I suppose as an OT, you've got quite a lot of power, haven't you? Because you professionally have to decide whether you're going to make a recommendation that this is necessary and appropriate. So if you were going to put forward that, I think you wouldn't want to be arguing the first bit of F, would you? Because they clearly have got access to a room in which there's already a shower. But you'd have to argue it under the second bit. On the shower, you know, the fibromyalgia example, I think you'd have to argue it on that ground. But if there was sufficient evidence that the fibromyalgia made use of the shower completely unreasonable, then you might say, well, we really do need to facilitate reasonable use by the disabled occupant of the bath. I mean, that's one way that you might argue it. But the pain relief, I'm just wondering whether that would create even more difficulty, because if they can access the wet room, well, they've got access to a shower, haven't they? And they can use it. It's just not having the same effect as a bath might in terms of pain relief. So I'm wondering whether, if you had a housing officer who was really trying to keep a tight control on DFG, I mean, I could see them not necessarily being that accommodating. But equally, and it'd be very interesting to know whether any of you have got examples of this, some housing officers, if they've got plenty of money and they're feeling nice and they get on well with you, they might just wave it all through anyway. Of course, if you were blocked here, you've always got the regulatory reform order to turn to, because, and here's an interesting point, you see, we've got, haven't we, we've got the Housing Grants Act, we've got the regulatory reform order. Now, I was talking to an area some while ago, I can't even remember where it was now. Anyway, the point is they were revisiting their regulatory reform order policy, because, under the regulatory reform order, each local housing authority must have its own policy, and these policies are going to differ. Now, the person partly responsible for rewriting it, I understood them to say that they were considering things like, well, under the new policy, how much might they top up a DFG? But I pointed out, and I remember him saying to me he hadn't really thought about this, that actually you could use the regulatory reform order for adaptations that simply don't come under the Housing Grants Act at all. Because there are things that aren't going to come under the Housing Grants Act. And if locally they decided, look, we're not going in for pain relief by way of DFG, it wouldn't preclude use of the regulatory reform order as long as the local policy has been made in a reasonable, flexible way. I don't know. What do you think? I don't know who asked this question, of course, because it's David's just forwarded. So, I mean, have you had success, say, with the pain relief or the fibromyalgia thing in trying to get a DFG, even though somebody's already got access to, physically to the shower or something? Or anybody else, even if it wasn't you who asked the question.
We've addressed a similar need, not via DFG. It was via social care funding. South Gloss, we were able to fund up to £2,500 for under our Care Act obligations. So the person had access to a level access shower. They had, I think it might have been fibromyalgia, and they weren't finding the shower was suitable for them, and we assessed them and we came to the conclusion that the provision of the bath was an appropriate option.
Yes. Yeah, thanks, David, because of course beyond the regulatory reform order to deal with that, you could always then fall back to the Care Act for adults or for children, of course, as we've already said, the Children Act and the Chronically Sick Act. But there was a case, just bear with me, see if I can find it. There was a case about somebody and a shower and all the efforts the OTs made. Sorry, forgive me, bear with me a moment. See if I can find the case. I mean, I remember the facts of it. I just can't remember the name of the council. About our shower. Well, I'll tell you, while I'm looking for the local authority, what it was a woman who had a shower, but she said that, oh yeah, here we go. So yeah, the reason I thought this might be useful. It's not quite the same as the one you said, but what she was saying was that not enough water pressure in the air, so an electric shower, that's right. There's not enough pressure to wash properly. Why this all got mixed up with medical things was that social services said, okay, let's put a mixer shower in. She said that still wasn't good enough. And now she wanted a bath and a shower. And the GP then wrote in support saying, you know, psychologically, this was all very stressful, so to give her whatever she wants. But I mean, and GPs do say that, don't they? Now, what she said was that the water pressure was inadequate to wash off ointment for medical conditions. And it took her 20 minutes to get the ointment off. And then there was the issue of controlling the steam and goodness knows what else. Anyway, the thing is that the local authority, with her permission, contacted the GP, who actually said it's not a bad idea she keeps some of this ointment on. She doesn't need to get it all off. You know, it would probably be good if some of it was left on. And the local authority, again, with her consent, contacted the psychiatrist. And he said, actually, in this case, there were mental health issues. Now, you see, that's quite interesting, that one, because, you know, because that was then followed by the GP, to, you know, recommending high pressure shower and bath installation. But you see, the local authority was trying to say, look, this is more complicated. And it was as though that medical and maybe mental health issue was taking it out of the realms a bit of what reasonably might have been done either via DFG or through social care. Anyway, if that sounds of any interest, you might want to look that one up. Sorry, I haven't got all the links. I'm too old-fashioned, aren't I? But you'll find that one easily enough on the local government ombudsman website. Right. So should we go back to these? Get rid of all that stuff. Go back to the questions. Yeah, now this third one, see, I suddenly thought, well, this was going to be an issue because it says the Care Act tells us that a local authority should fund up to £1,000 towards minor adaptations. And a similar duty exists for children. But that's not quite right, is it? Because the Care Act doesn't say that. The Care Act says that there are certain things under the Care Act that must be free of charge. What are those things? Well, one of them is reablement for up to 6 weeks. Over 6 weeks, it's chargeable, although the council doesn't have to charge, it can do. So just in case some of you get involved in reablement, really important to know that reablement in law is not necessarily confined to 6 weeks, and that if somebody's doing well at 6 weeks, you should feel free to argue in an individual case that the reablement should be extended. And that's just by the way. The second thing that must be free of charge is community equipment. So equipment, no matter what its cost, if it's being provided under the Care Act, must be provided free of charge. The third thing is a minor adaptation. And a minor adaptation is defined as an adaptation costing £1,000 or less. That must be free of charge. But it doesn't say anything about not funding adaptations over £1,000. All it means is that if social services provide adaptations over £1,000, they can financially means test if they wish to, although they don't have to, because something that's sometimes forgotten is that all charging, all means testing under the Care Act is discretionary only. You know, all the charges for care agencies, care home placements, a revolutionary local authority could do away with them all. from next April the 1st. Hammersmith and Fulham, I don't know whether any of you work down in Hammersmith. Those of you who don't may not believe this. They don't charge for personal care in people's homes as living proof of the fact that there's not a duty to charge. So what I'm trying to say, we're going to need to be very clear that this £1,000 rule is not about what social services can fund up to, and above that, it's got to be something else like housing. That's not correct. There is no rule like that for children. The regulations that set this rule about the free equipment and the free reablement and minor adaptations of £1,000 or less all being free, there's nothing there for children under the Children Act and the Chronically Sick Act. There are separate issues around charging for children. So when you say the question ends, well, what level should a local authority fund? Well, that's the point, isn't it? That when the DFG guidance says, look, social services must remember the bottom line is that if somebody's needs are not met through the housing route, they have to consider their duties under the social care legislation, just as in David's example a few moments ago. So there isn't guidance on how much local authorities should fund. What some social services do, of course, is say, well, we're happy to provide up to X in terms of help with adaptations, X amount. But you see, that isn't right, really, because, look, shall we, just think, you might not believe me, it's fair enough, but why don't we find the bit of the guidance that talks about this? Yeah, so look, what's it saying? The responsibilities of social services are this: the Care Act, you know, adults, children. And actually, of course, you might say the second paragraph is contradicting what I've said. Well, the guidance is simply wrong. Okay. The guidance doesn't include a duty to provide minor adaptations up to the value of £1,000. All it says is that anything up to 1,000 must be free. That's a reminder that the people who write guidance don't always pay attention to what the legislation states. Sorry, I hope that doesn't sound arrogant or anything, but it's if you look at the regulations are absolutely plain under the Care Act, and whoever wrote that didn't look at the regulations properly, or at least they did, but they've expressed it badly with respect to whoever wrote that. Now, what's it saying? So where an application for DFG is being made, blah, 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 social services should obviously work closely with housing. Where a need has been established, it's their duty to assist, even where the housing authority is unable to approve or fully fund an application, or where the applicant has difficulty meeting their assessed contribution, social services can step in. Or, and this is what we mentioned a bit earlier, supposing a disabled person's assessed as needing an adaptation that certainly doesn't come under DFG at all. All of that can go back to social care. And so if you ask, well, what's the amount social care should add in? Well, there is no amount, is there? Because, as we said earlier, what would determine how much should be added in by social care would depend on what the eligible social care needs are and how social services identify whether the assistance with adaptations is a cost-effective way of meeting the need. So, for example, there's been, you know, another recent case, and I'll find that as well, actually. So I thought it was quite a useful case, but I'm going to...
Can I add something to that? Because the question about the Chronically Sick Act was mine. We've got a scenario where at the moment we've got quite a number of children's cases where the cost of the assessed cost of the adaptation exceeds our mandatory grant and our top-up grant.
Yes.
In one of the situations, the cost is coming to almost 280,000. We've funded 90,000. So we've provided 30,000 of the mandatory, 10,000 from our off, 10,000 from our top-up budget that is at the office discretion, and then we have a special DFG we have a specialist panel that looks at cases that require further top-up, and we've been able to secure an additional 30,000. So in total, we're able to provide 90,000 from DFG funding. So our social care are looking at their options in terms of what they can fund. The property isn't owned by it's a housing association property. In other circumstances, we've offered loans to owner occupiers because we can apply a land charge.
Yes.
What's the kind of the situation with housing associations? Because obviously if we can't offer that individual a loan and secure it against the property or apply a land charge, and they're not eligible to apply for, we've also got in the Southwest, we've got an organisation called Lendology, which South Gloss and a number of other authorities can direct individuals to help pay for fund the contribution or fund sort of top-ups, or where cost of works has exceeded maximum allowances and discretionary top-ups and all of that.
Well, that's interesting, isn't it? So first of all, and I think this will feed into what you've asked. This case was where it was a family and the need for significant adaptations. And first of all, talking about £65,000, and then now it had risen to anywhere between 86,000 and 103,000. Now, one important thing, perhaps looking at it from a legal point of view, is that what the Ombudsman was looking for here is that if Bradford were going to say, we're not doing this, too much, see at the bottom, they're saying loft conversion no longer viable. You know, the Ombudsman, as I'm sure you all know, like the courts, are interested in decision-making process. They don't really care whether somebody gets an adaptation or not. They want to know how the decision's reached. What the Ombudsman wanted to see was a record of the decision-making in sequence, as it were. First of all, had the DFG steps been gone through, you know, the necessary and appropriate, the reasonable and practicable, how much money was available there. Then had, well, what was called discretionary grant, which in this case would be covering both regulatory reform stuff and Children Act, Care Act stuff. He's 20 years old, isn't he? So because of a failure, before Bradford said no, the Ombudsman wanted to see the steps, you know, that Bradford could show they'd gone to each bit of legislation and considered what duties or powers would be available. So that's just one thing. You know, whatever you decide, David, in a case like that, you need a very clear record showing that the different legislation, what one's looked at. But I suppose the second thing is that if we just now talk about, as you're saying, this burden has come back to social services. So we just, here's our legislation. And you were saying it's a children's case, is that right? So it's very much about saying, isn't it? Are there needs? You clearly show what the assessment of need is under the Chronically Sick Act and the Children Act. And particularly under the Chronically Sick Act, once you've identified this need that really does need to be met, you have to do it. And the question, as we said, cost-effective options. So if you're then looking at how much money you might be prepared to put in, it would really need to be on the basis, wouldn't it, is that one way or another you need to meet this child's needs. And that means, of course, you need to look very, very hard at how you define those needs and very hard at what options there might be to meet them. So you don't just automatically get locked into a £250,000 adaptation. But that said, if all your views, you know, all the professionals involved say that without this adaptation, consequences A, B, and C would follow, and they would be significant and potentially serious, then of course that points to social services maybe having to entertain the spending of a lot of money. You then pointed out that if it were an owner-occupier, you could slap a legal charge on the home with luck. But you can't do that with a registered social landlord. Now, the difficulty is you can see why it would be pragmatic to say, well, we're happy to spend another £100,000 on meeting this child's needs as long as their parents are owner-occupiers. But if they're not, we're walking away. But that won't do really, will it? Because
no, it's not fair.
A child's needs don't depend. No, so I'm not suggesting you would walk away, but I mean, I have come across this in other councils, you see, where the social services says, we're happy to put a load of money in, but only for owner-occupiers. But, you know, in a sense, you could argue that's highly discriminatory, and it leaves a very disabled child whose parents aren't owner-occupiers at potentially a hugely significant disadvantage. I haven't given you a nice, easy answer there, but I mean,
You haven't, Michael. No.
I mean, that's the hole you're in, isn't it?
Yeah. So, I mean, given the picture of our dwindling resources, is it? I guess, I suppose what we're wondering is the sky the limits in terms of if we've assessed the need and it costs 300k to meet it, have we got to find that 300k from somewhere?
Yeah, but this is the thing, isn't it? Surely in determining what the real need is, you're looking at needs, you're looking at consequences of not meeting it. And certainly when I used to have regular conversations about this with one particular council lawyer that I knew, because he had a particular interest in adaptations, and actually for some reason, particularly with children, I think because he'd worked with children in the past as a social worker, I'm remembering rightly, that he would go through with senior managers saying, well, look, if we don't provide this really expensive adaptation, what might the consequences be for the child? And obviously every case is different. But what one of his arguments would be, look, it's no good talking budgets here, because it's no good saying we haven't got the money in the adaptations budget if the consequence is the child's going into care. Cost us 5 times as much. I know that's a simple example, but that's the sort of thing that he would push senior managers on when they were trying to work out how much to spend on adaptations. Wouldn't be surprised if some of you were saying, but what makes you think that councils can fish out £200,000 at the drop of a hat for the social care budget? But of course, bear in mind, there are vast sums of money spent on other children, aren't there, in care, children with very high needs. Vast sums of money, increasingly so, spent on adults with complex mental health and psychological needs or profound physical disabilities. So the spending of large sums of money, you know, one shouldn't exclude physically disabled children from sometimes entertaining the idea that a large sum of money may need to be spent, if you see what I mean. Even though I can see everybody getting very anxious when you're talking about so much money. I mean, understandably so.
I mean, would the final arbiter of what would be deemed reasonable, would that be a judge, effectively?
Well, I don't know about that. I mean, if there's a dispute, it may need to be. Well, I'm not sure about that at all. I mean, surely the real arbiter of what's reasonable is, I mean, you could say, just from a pragmatic point of view, look, the greater the needs and the more the money involved, you want to be absolutely, you know, triple careful about how the assessment has been done, how the needs have been assessed, what all the options have been. And then you surely start to boil down what's reasonable. I mean, the only way it's going to go to a court is if, you know, you dig your heels in and the family's a family who's prepared to go to a solicitor and do a case. But I mean, that again disadvantages an awful lot of people, doesn't it? Because most people, contrary to what you may think, most people certainly don't want to go to court, and actually most people don't even want to complain. It's only a very small number of people who want to complain, and to tell you the truth, I've got the durability to do so, because even complaints can be quite an arduous process.
Thank you. So I sort of answered my question.
Yeah, I mean, look,
what did you need to do it?
I don't know whether this is relevant or not, but I'm hoping it may be. I was talking to somebody else the other day about this, actually. I mean, I remember talking to an OT manager. I imagine she's long since retired some years ago, maybe not. But anyway, she was telling me that there were some cases where she and her OTs would look at a particular case. Child, actually, the example she gave me, child in his teenage, possibly higher teenage years, it had some accident, I think, or something, and was clearly going to be living with a family for a long time, very disabled, but they were really looking not just at what adaptations would be needed for the immediate needs, but also looking a few years down the line. He said sensibly. Now, the immediate needs, she said, well, you know, maybe we could have done something for 30,000, but looking down the line, cost, well, now with building costs having gone on, I think probably the equivalent now would she be looking at 120, 130,000 pounds worth of works, which didn't go down well with senior colleagues, but she said she absolutely stood her ground. Now, you don't do that in every case, but she felt there was a strong enough argument that to, as you said, reasonably meet his needs. That's what you want to hold out for. But that didn't need to go to court or the Ombudsman. That was a senior professional OT standing her ground and arguing for what she thought was right. And of course, a lot of that funding in that case would be from social care. Should we go back to the questions? Because I don't think I've got through them all. Got a bit diverted there. Sensory integration. I'm not sure I quite understand that. I mean, DFG, yeah, I'm not sure I fully understand that, actually, because I suppose it depends who you are, whoever's asked this question about this sensory integration assessment. And if it's social services OT, it's part of your statutory function. You're advising whether the works are necessary and appropriate. So, you know, DFG funding doesn't cover that assessment and recommendation that you make as a social services OT. A DFG funding can, of course, include, supposing a private OT provides some input further down the line or something, the DFG funding can cover some of that, can't it? So I'm not quite sure what all that was about, actually. I mean, you'd have thought that the bigger and wider assessment of the child's needs would probably take place under the Children Act and the Chronically Sick Act, I'm assuming, and then work out, you know, well, how much might diet work, how much might other forms of intervention work. Where it might come in, I suppose, is that in a case some of you may know, or maybe you all know, I don't know, an old Calderdale case, but it's, I say old, well, it is, it's 20 years old now, but it's a Court of Appeal case. You know, okay, some of you will have come across about whether this family could get a DFG for a loft conversion to separate two of the four siblings they had. The two older brothers were sharing this bedroom. The older brother was autistic and would attack his brother all through the night and stuff like that. But one of the issues was, which may be a parallel with what you've asked in this question, is whether other interventions would mean that the separate bedroom wasn't necessary, you see, and therefore whether the local authority OT should say, well, the loft conversion to create a separate bedroom is not necessary and appropriate because this need can be met in a completely different way. But I think the problem in that case was that there had already been interventions from CAMS, from health visitors, NHS OTs, all trying to work with the child to tackle this behaviour. And I think when you read the case, it doesn't really sound like those had noticeably done the job. And this issue of what happened at night was a continuing safety issue in the household. That was a council house, actually, I think. And the thing is that in that case, very interestingly, and also some of you may remember, the court said if you apply for a DFG on grounds of safety, use safety in the dwelling, it doesn't. You don't have to argue that's going to make the dwelling absolutely safe. What you have to argue is that the adaptation would make it significantly safer, which is quite useful to remember. The next question I've already dealt with. I mean, if you want to know where social services regularly top up and what they do, I suggest using your OT networks. Yeah, well, the thing is that this is registered social landlord property, isn't it? Housing association. We said, so stop me if I'm on the wrong track here, whoever asked this. We said, haven't we, that DFG is available in all tenures. Clearly you're subject to landlord permission, but it seems like the housing association is actually would welcome a DFG. So if grants then say, oh no, sorry, family have got to move, well, I think that's got to be suspect. After all, if the judge in that Islington case, the McEwen case we mentioned earlier, if the judge said that council tenants shouldn't be treated differently for DFG purposes than private sector tenures or owner-occupiers. The reason the judge said that is that Islington in that case were doing what's happening in your question here. Islington were asking that woman who wanted the external platform lift to move. Well, the judge was effectively saying, had she lived in the private sector, that's not what the council would have been saying. So the judge said, why are you treating her differently because she's a council tenant? And I think really the way to argue what you've put in there is that if the child meets the DFG rules, the conditions, and if the landlord, as it seems they are, is more than happy to do it, I think housing can't just say, oh, well, sorry, they've got to move. I mean, that's the tack I would take anyway. And I think that is, there's a legal basis for doing that. Just lastly, I'm aware there's a few hands. I don't know, Michelle, was it yourself who asked that question? Michelle.
Hi, sorry, Michael. Yes, sorry. No, it wasn't me that asked the question. It was just that in our local authority, our principal housing association, Stockport Homes, does do adaptation works that aren't DFG funded, and but they have within their own policy that if an adaptation is likely to be an extension or £30,000 worth of, up to £30,000 worth of work, they would want them to consider rehousing and options about their rehousing. Options in the authority near where they live would be explored for 3 months, and then a further 3 months before they would then consider processing it through. But that's to do with their policy. It's not to do with the DFG policy. It's to do with their own housing, their own, Stockport Homes policy. And some families have argued, have argued that they've been prepared to wait to see if something more suitable came up within that 6-month period. But then they also say, why am I having to wait an extra 6 months before you even start the process of adapting?
Yeah, actually, Michelle, sorry, what you said is useful, because of course I omitted something in answering this question, which I know you didn't ask. Of course, the issue of applying the DFG rules and saying the child should be entitled, or the parent should be entitled to the grant. Of course, it's much easier to argue that if it's under 30,000, because obviously 30,000 is a mandatory thing. Over 30,000, of course, I think this is maybe what you were getting at. It all becomes a bit trickier, doesn't it? Because under the regulatory reform order, there isn't a duty to automatically come up with extra money. Not necessarily. I mean, some areas will do automatically, but others won't. So over 30,000, it becomes trickier. The thing about the Islington case, where that woman was asked to move, is that the cost of what she'd applied for only came to about 23,000, so she was well within the 30,000. I don't want to exclude Wales, and there is a last question here from Wales. Now, I'm assuming we're talking here about DFG recommendations, and as overcrowding,
yes,
and as paediatric OTs. Now, you know, the DFG rules apply in Wales, not exactly the same, you know, as a different maximum amount, isn't it? I think it's 37,000 in Wales you get, but the basic rules are the same. But in fact, the Act is the same. It's just some of the details are different. But obviously, you say paediatric OT, so I'm assuming we're talking about social services OTs. Remember, it's social services.
That's how I read the question. I'm not sure who submitted it.
No,
because they were submitted
but let's say it's social services OTs. Just sometimes when people talk about paediatric OTs, they're referring to NHS OTs, and that's something different
that way.
Yeah. They don't want to ruin the relationship with the parents. There's no diagnosis, but the OTs are still sending a supported recommendation. Now, of course, one issue about that is that if this recommendation is being made under the Housing Grants Act, it's whether the works are necessary and appropriate. And look, obviously you want to work with parents, don't you? And the guidance says that when you work with children and their families, you really must look and listen carefully to what the families are saying, and you must consider the whole situation. But nonetheless, if one's harsh, and I don't mean to be, you don't want to say something's necessary and appropriate, because you don't want to ruin the relationship with the parents. I mean, put like that, that is not a ground for saying that something's necessary and appropriate. Also, and I don't know, some of you may have had experience of this, but OTs do tell me that they sometimes feel they're under colossal pressure. And sometimes, maybe less experienced OTs, I don't know, tell me they sometimes even feel intimidated. Now, maybe I'm talking to the wrong OTs. Maybe everything's happier than that, but that's what I'm told. That's no basis for making a recommendation. That's the first thing. The second thing is that to entertain a DFG, there has to be a disabled occupant. And disabled occupant, and look, I'm not going to look at the slides anymore after this because we're running out of time, aren't we? But if we just do go to one last slide and we look at the definition of disabled occupant, this is it's rather old-fashioned wording, isn't it? Sight, hearing or speech substantially impaired, mental disorder or impairment of any kind, substantially disabled, illness, injury, impairment or otherwise. Now, your question is, well, I assume from what you've put there, what about this absence of diagnosis? Now, very interestingly, I don't think that's necessarily an impediment. Two parallels, which I hopefully will be of interest anyway, is that under the Care Act, just by way of a parallel, in order for somebody to be eligible, there has to be a physical or mental impairment or illness. And the Care Act guidance, which is statutory guidance, states that if you haven't got a diagnosis, it's still up to the assessor on, I suppose, if you like, on the balance of probability to make a decision about whether it's more likely than not that there is an impairment or illness. So in other words, the Care Act guidance is saying in order to decide whether there is that physical or mental impairment or illness, you do not in every case need a formal diagnosis. The second parallel, which hopefully may also be of interest, is that you'll know that under the Mental Capacity Act, the test of capacity is that, first of all, somebody's unable to understand, to retain, to use and weigh the relevant information, and unable to communicate a decision. And if they can't do even just one of those things, then you have to ask the second question: is their inability to do so because of an impairment or disturbance in the functioning of the mind or the brain? Now, in 2 or 3 recent Court of Protection cases, the courts have said even there, you don't necessarily need a formal diagnosis. And the draft Mental Capacity Act code issued about 18 months ago now says the same thing. So look, this hasn't been tested that I'm aware of in any case, but it seems to me that if that's the drift in both the Care Act and the Mental Capacity Act, you could reasonably say, well, you could take a similar decision here, even in the absence of a formal diagnosis. David, I dare not look at the chat. I'm assuming there might be some unanswered questions, but we're sort of at the end of time, aren't we?
We are, yeah. There was one in the question and answer bit.
Do you want me to take that last one?
Yes, if you wouldn't mind, because they have been patient. They did ask it earlier on in the chat. So the question is, where do we stand if we made rehousing recommendations around what type of property would be suitable based on assessment of housing needs, and a private OT then states there are additional needs? Which should we be meeting?
Yeah, so this is presumably where the rehousing responsibility comes under the Housing Act, I'm thinking. The Social Services OT is asked for their views to feed in to that whole rehousing issue, maybe, as you say, the type of dwelling and what will be reasonable, and maybe priority as well can come into it. But it is a housing decision, isn't it? Ultimately, it's a Housing Act decision. Now, I would say that so housing gets your view as a social services OT, let's say, and then a private OT quite separately feeds in and says, I think X, Y, and Z. Actually, I would say that's for housing, because it's their decision. Housing Act 1996 decisions aren't to do with social services OTs directly. It is how I think I'd respond to that. If, of course, it were a DFG, that would be different, because in law, the social services OTs are asked whether it's necessary and appropriate. If a private OT chips in for a DFG, then I think the social services OT, it's still up for the social services OT to say what's necessary and appropriate, and it's for housing to listen to what the social services OT says, but the social services OT should take account of what the private OT says. And ideally, if the social services OT, in recommending about the DFG, is not going to go along with what the private OT said, you want some reasoning as to why, justification. But I don't think, this is just off the top of my head, I haven't really thought about it, but with a rehousing issue, but I don't think you need to worry about that. That's for housing to worry about. So from their point of view, what have they got? They've got your recommendations as a social services OT, they've got the private OT recommendation. It's up to them to do what they will with those, I think, would be my response.
Thank you, Michael. That's actually quite useful for me. I was an OT as well. It's quite useful for me when people are asking questions.
I mean, David, just one thing, if you don't mind. I mean, if there's another minute, just to draw a wider point from some of all of that. First of all, there was a case, and this is an important wider issue, actually. There was a case in Haringey, I don't know where anybody here from Haringey, where an OT made some strong recommendations about the priority and the urgency with which a mother and her autistic child needed to be rehoused, because he was at really, really high risk in a first floor flat. And the OT and social services made a very strong recommendation, well evidenced. And as we've just said, under the Housing Act, it's housing to make the decision. And one of the things they did in saying, well, we don't think it's this urgent, because after all, if he jumps off the balcony or the window, it's only the first floor. How much worse would it be if it were the 10th? Well, of course, by the time that got to court, the judges were having none of that, as you can absolutely imagine. But you could argue, therefore, the OT in that case played an important role. The second really quick example, but on the same broader issue. A few years back, there was a case in Southwark where there was an independent OT involved. And the independent OT did a really comprehensive assessment about the complex needs of this woman living at home with parents, both physical and behaviour and mental health and everything. But obviously it was a Care Act case, so it was social services decision as to what support should be given to this woman. Now, the social worker in that case, this is the way the report's written up anyway, the social worker in that case, after reading this really detailed OT report about all these needs this woman had irregularly but constantly through the day and night, and all the support she would need, the social worker came up with 2 hours a day. Now, you know, we're saying that what the courts are interested in is decision-making process. So the judge said, look, we as judges don't like interfering with what social workers do with their professional judgment, but there does need to be a semblance of rational decision-making. And when you look at the detailed OT report on the left, and then you look at the social worker's 2 hours a day, the social worker provided no rationale, no reasoning, no justification for essentially ditching much of what the independent OT had said. And consequently, Southwark lost the case. So in that case, the independent OT played an enormously important role. It wasn't their decision, but they obviously put pressure on Southwark, and Southwark, in the judge's view, did not respond rationally. Had they responded rationally and said, here are the reasons, A, B, C, D, and E, why we're not going down the independent OT's road, then maybe Southwark would have won the case. So I hope that's, I mean, actually, that's a shout, isn't it, for the importance of OT assessments, whether it's, because the same would have been if that OT had been a social services OT and a social worker had said, oh, we're not having any of that. These OTs don't know what they're talking about. We'll just put in 2 hours a day. Well, it would have been the same thing. You know, it would have put Southwark in a difficult spot if they completely ignored an expert assessment from an OT, in-house or out-house, so to speak. Sorry, David, that's just a post.
No, that's really useful. No, that's really useful. Has anybody? Well, I just wanted to say a very big thank you to Michael for joining us, and thank you for running over as well a little. That's great. Oh, get my brain into gear. Oh, I've lost my train of thought there. So the recording will be shared by in the next newsletter. It won't be in the October one, it'll be in the November one, because the deadlines for getting stuff into the newsletter is the 10th of the month. So and I will put a link to all of the resources that we put in the chat as well, so you've got those to look back on. But Michael, thank you very much. It's been hugely informative, as it always is.
Yeah, David, just on a downbeat though, because if this is all recorded and you're going to have stuff in the newsletter, just obviously to emphasise that everything I said today is not to be taken as legal advice.
Not illegal, yeah, not legal advice.
I'm giving pointers off
No,
the
absolutely.
top of my head, and obviously legal advice needs to come from people's legal sections.
Yeah, no, absolutely.
Sorry, I'm just being. I'm covering my own back there, but
no, absolutely, Michael. No, we'll make that perfectly clear, because you're not. You've sort of answered questions from small snippets of information, and as you rightly point out, it's not legal advice. It's more kind of to help us with understanding the legalese that we work within, rather than specific advice on specific issues. But yes, I will pop that disclaimer in the recording as well. But again, thank you very much, Michael. It's always a pleasure to have you come and speak to us, and I always walk away learning lots of new different things.
Well, anyway, no, thank you very much for asking me, and thanks all for coming. Yeah.
There we go, everybody. There will be, when you leave, there will be a quick survey. So if you could fill that in, I'd really appreciate it, because it kind of help us just work out what other types of webinars you might be interested in, and actually how you found the organization and the booking and everything else. So we need to gather some feedback to work out what you want next and what we can do next for you. But again, Michael, thank you very much. It's always a pleasure to see you.
Yep. Thanks again, David. Thanks. Bye-bye. Bye.
Thanks. Bye, everybody.